4 things that I think are key to a landlord in 2025. If you haven't done it before, or if you started off a lease and none of this was on your agenda, I strongly recommend first that you work on your communication. Your communication is key to you getting all of your expectations properly across, and for making sure that if your tenant slips slightly out of line, that you have notified them of it adequately. Too many times landlords, simply expect their tenant to do the right thing, but they haven't really explained what that is. And so a tenant may not have a clear expectation of what the right thing is, even if it's in black and white in the lease. Not every tenant's good at being a tenant, so it's helpful when a landlord with experience goes and kind of sets some guardrails and some reminders that help tenants succeed. Good communication is a key to that. And so one of the things that I see, one of the deepest, darkest, baddest sins that I see landlords committing is leaving the notice provision on their lease either blank or sorely deficient. There might be one email in there tops. And sure, you can always communicate with your tenant at the property, but not every landlord is set up to go and physically visit the property. Additionally, when it comes to effective communication, I just don't recommend exclusively limiting your communication to oral communication. There's no record of what you said. There's certainly no record of what they said. And I know a lot of us start going with our cell phones in our pockets and we press record and we're thinking, oh, this is going to get them. So if they say something that is harmful or is a breach of the lease, I got them right here on my camera, or I'm recording the audio. And let me tell you, for all of these cases, very rarely do those things actually come into play. First of all, the recording is usually terrible. The quality is not good, and or it's hard to identify who is speaking and whether or not precisely it's good evidence, because you can't easily identify what's being said or who's saying it. And sometimes if things are taken out of context, the court's not going to really accept it as viable evidence to prove your points. Instead, communicate in writing. Your communication is always better when you do it in writing. And so I always tell landlords, number one, if your notice provision allows you multiple avenues for communication through, say, text or through a tenant portal or through email, along with regular and certified U.S. mail, use all of those methods to ensure that your tenant gets your message. But certainly if you're going to communicate adequately with your tenant, you want to do it in a written form. And so I tend to favor text communication the absolute least, because it is the least formal. And I know you can be informal in an email, but if you conduct yourself in a business-like manner, my recommendation always to landlords is to send email as though you know that message is going to be presented in front of a court. If you would be ashamed to present your words to a judge in live court, then don't ever click send, because chances are you might have to show it to a judge and you might have to account to that judge for your statements. So whenever you're communicating notices to your tenant, do it in writing. If you're going to do it by email, make sure that email is in a business-like presentation, something that you would not be ashamed, in fact, something you would be proud to show to a judge in the event it ever has to be presented as evidence in a court case. Now, I started off by talking about how landlords sometimes have the deficient notice provision. Your lease may have total blanks or very little information. You might want to then amend that lease, and it's not complicated. As long as your tenant will agree to an addendum to your lease, you can modify the notice provision for their benefit and yours. And you just present an additional sheet that is an addendum to your lease. It says, look, for notice provision, we agree that the lease signed on date X by landlord or landlords and tenant or tenants will be modified to reflect the following. Notice is proper between the parties regarding this lease by X to the tenant and Y to the landlord. And so it may be that you have, for example, a personal email and a work email. And if there's multiple tenants, a husband and wife combo, you have 2 emails for each of them. The more access you have, the less likely you are to be completely ghosted, or for someone to say, I never received that notice, because you only sent it in one way and somehow it didn't get there, or they can make a claim that it didn't get there. I've had that issue raised in court before, where a tenant said, look, he sent it by email maybe, but I never got it. But if you're sending it to 4 different emails and all 4 claims are I never got it, it's much harder for the court to believe. So keep your communication in writing. Make sure you have multiple avenues of communication for notices pertaining to the lease, and communicate. Make sure that what you're doing is getting your message across, your expectation, and what you want your tenant to know, whether that's a payment reminder or whether that's, hey, bad weather's coming, let's be ready for it in accordance with your lease. Or it's a matter of, look, I'm issuing you a notice of default because you left your trash cans out and I got a letter from the HOA. Please follow that HOA restriction. So always, always, always improve your communication. If your lease is in place and you need to modify it, again, a simple addendum can do it. As long as all the original parties to that lease sign that addendum, it becomes part of the lease, even after the fact. If you're starting a brand new lease, mention multiple avenues for communication in your new lease, and do this always. You have multiple tenants, get multiple emails. If you have a tenant portal, disclose that as a method of notifying your tenant. Again, text, you can list it, but I wouldn't make that your go-to, particularly for very important notices. So next, you want to improve your inspection in 2025. If it's been more than 6 months since you've been on the property, that's dangerous. You're leaving your most valuable asset susceptible to damage that you're going to have to pay for if that tenant leaves before you ever find out about it. So make sure you plan your first inspection in 2025 if you haven't done it yet. I would strongly recommend that you follow the guidelines in your lease and whatever local law allows in terms of you stepping in. Some leases don't require much notice at all, whereas other leases require very specific kinds of notice. You might have to give 24 or 48 or 72 hours of written notice. If that's the case in your lease, follow what your lease says. But certainly make an effort to go and inspect that property. You want to make sure that, number one, your baby is well taken care of. Remember, that rent property is your most valuable asset in the whole agreement. Rent, sure, that's great, but a few months of rent doesn't compare at all to the destruction of your rent house. So you want to keep your eyes focused on what's the absolute most important thing here, and it's that property. Make sure that you schedule an inspection so you can make sure that, the floors are fine, the walls are fine, the appliances are working, that the toilet flushes and the water flows in the shower, that there aren't any holes on the roof, or leaks through the ceiling, that the insulation is good, that the AC is functioning properly. And what I recommend to landlords is, look, the way you present it isn't, well, I'm going to go in to see if you're messing up my place. That's a bad, basis to enter the property. But instead, if what your basis is, look, I want to make sure that everything's running properly. I want to make sure you're good for the next few months so that you're comfortable and that everything is tip top. And if it turns out there's a little problem, I want to fix it quickly so that it doesn't become a big problem. Now, there are some tenants who are very adamant and say, look, I just don't want you in the house. Don't worry. If there's a problem, I'll call you. This is not a solution to that problem. In fact, it may be a red flag that the tenant is trying to hide something. And sometimes when you do an inspection, you're going to find things like unauthorized people or unauthorized pets, or that they've altered the property in some way and caused you damage. There might be a really good reason from their perspective to not let you, the landlord, in. That is a red flag. In fact, If I'm hearing that from a tenant, that means I got to get in sooner rather than later. And if your lease specifically allows you the ability to inspect and they straight up deny it, that's a notice of default. And make sure that you are documenting this. This might be somebody you have to get rid of. And it may just be that, they don't feel comfortable. Unfortunately, that's not a good enough reason for you to leave your property at risk. So work with the tenant, but not outside of the realm of reason. If they, again, strongly object, you have to meet that with a notice of default, specifically in response to which provision of your lease has been violated by them not letting you enter. So we start off with better communication, better inspection, and next we want better calculation. You want to make sure that you are applying all of the payments that you receive in accordance with what your lease says, particularly those of you who have an application of funds clause, which says, look, you owe multiple fees outside of the realm of rent, and I will apply them in accordance with the debts you owe in accordance with the time frame in which you owe them, right? You don't want to apply rent to some future month and say, well, you're delinquent in the current month. That doesn't make sense. But certainly if you get a payment, let's say in January, but there are things from December, maybe even from November, that are lingering that haven't been paid, maybe late fees or repair costs or HOA violations that the tenant was liable for. Don't let these things linger. Make sure that the calculation of your ledger is timely and that it reflects the oldest debt being paid first. You should always follow your lease and its guidance as to whether or not you can take any payment, no matter how it's designated. You can take any payment and apply it to the oldest debt first, thereby leaving your ledger absolutely up to date. I don't know how many times I see landlords show up to my office with gaps in their ledger. They say, well, this is from 8 months ago, and this is from 6 months ago, this is from 3 months ago, and wait, this is from years ago. They owe me, and they've owed me this debt for multiple years. And I tell them, look, don't expect the court to bail you out on this one. There is a doctrine called the doctrine of latches, which basically says, look, if you sit on your hands and don't take care of something and just let time go and go and go, that probably indicates it's not that important. Why do I have to see it as important now? So in your calculation of what is currently owed, make sure that you are applying your rent in accordance with what your lease already allows you to do. If you've got an application of funds clause, clear out all of the oldest debt first to make sure that your lease makes the most sense. And here's another thing that we know, particularly in the state of Texas. I know that it's not possible to evict someone for an unpaid deposit or for damage fees that they didn't pay or for late fees that they didn't pay in the prior month. But with an application of funds clause, if I apply any subsequent payment to each of those very valid fees first, and there's now a deficiency in the rent, well, by calculating properly what amounts were paid and where they were applied in my rent ledger, I can now proceed potentially with a notice to vacate on the basis of non-payment of rent as opposed to fees. And this, every eviction court in the state of Texas will accept. You can't evict on the basis of fees, but every single time you can evict on the basis of non-payment of rent. So make sure that your calculations of your fees and their application on your rent ledger are accurate and timely. And the last one, make sure you improve your execution of your lease terms in the coming year. If this is something you've been a little queasy about or a little maybe intimidated to do, find a way to get right past this, because the next level for you as a landlord is to make sure that you are executing your lease in accordance with its terms, which means you are charging late fees every time your tenant pays late. Even if you haven't done it in the past, I would strongly recommend that you get started doing it ASAP. Don't let another month go by and say, well, I'm just going to waive them. I'm happy that I got the rent. That's not good enough. Make sure that you are collecting those late fees. Additionally, make sure that you're issuing notices, even if they pay all the rent and all the late fee, that you're issuing notices to your tenant that late payment is a default in accordance with the lease. So please don't do that again. Rent is due, usually. Rent is due on or before the first day of each month, and anything after that is a lease violation. So on top of enforcing your late fees, you're issuing notices, and not just for late fees. Maybe your tenant has a pet violation, or your tenant has an unauthorized occupant, or your tenant's conducting business on your property in violation of the residential lease terms in place between you and that tenant. Enforce, 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 enforce. Because unless you do, you're likely to be harmed in the long run. And what you don't want to do is just sit passively by, let the tenant do what the tenant's going to do, and in your mind think, well, they're only going to be around for another 7 months. Later in 2025, they will leave, and I will find a better tenant. Let me tell you, the key to better tenants is being a better landlord. I see it all the time. The best tenants somehow are matched up with the best landlords, not because of some cosmic principle. It's very, very simple. If landlords hold their tenants to the terms of their lease, and the tenant will either rise to that occasion and comply as they have agreed, or they're going to leave. And you're going to go find another tenant, and you're going to make it very clear to them what your expectations are. Again, remember we talked about good communication? That is a key to execution. In fact, the better communication you have, the better inspections you have, and the better calculations you maintain, the less enforcement you are going to need to carry out for your leases. It's just the way that it works. All of these things build on each other. And if you are willing to go that extra mile and take care of your baby, that rental property, the most important asset that you hold in the rental process, I guarantee you things will run much better for you. All right, well, let's get to our questions. Number one, we have, what is the most efficient way to collect judgments, even if it's not 100%? Also, tips on placing liens on autos or other property. One of my tenants actually owns a home, even though they rented from me for years. Well, one thing that we like to talk about in the state of Texas is a judgment lien. And the way we set those up in Texas is by taking a judgment and obtaining what's called an abstract of judgment. We then take that abstract from the court with certain identifiers from the tenant. Usually it's the last three of their social, the last three of their driver's license or state ID, and then their date of birth. And these help to narrow down to the named party in the judgment. So we establish a judgment lien by taking that abstract and filing it with the property clerk's records of the county where the judgment was issued, or in the county where the tenant now resides. Well, this is important in terms of enforcement, because if you can find either real property, like a separate house, that otherwise is not exempt from seizure, or perhaps vehicles like extra cars, which are not otherwise exempt from seizure, or assets in an account that you know of at a banking institution with an account number that you know of, with funds in that account that are otherwise non-exempt, yeah, you can go and collect all of that with what's called a writ of execution. So there are ways to collect even 100% of your judgment with interest. And you can do this by making sure that you have established what's called a judgment lien based, again, this is a Texas-focused procedure, but it's very similar in many other states, that you take a judgment and you record it as a judgment lien. Here in Texas, it's judgment to abstract to writ of execution. And essentially what the constables do with the writ of execution is and you gotta know where the judgment debtor is, and then they're served with this and they say, look, we've got in this county registered this real property or this vehicle or this account, and we're seeking to seize either the stuff or the money in this particular account. And the court will allow it as part of your collection process. Now, sometimes this gets kind of technical and it's not super easy for a layperson to do it, but it is something that you can find out how it works in your jurisdiction, and it's something that I strongly recommend. As far as sending your judgment debts to collection agencies, I've seen very, very little in terms of success when it comes to that. If, however, you have had success with a certain collection agency, send them my way. I'm happy to look into them and see if maybe it's something that'll work for my clients. But again, over the last 15 years, I've seen very, very little in terms of success with collection agencies. All right, Ernie, have you ever heard of the Waiver of Notice clause? Yes, waiver of notice happens in all sorts of other cases. I know for sure in family law cases, a party can waive notice. A party can waive notice in a probate matter and sign a waiver. But essentially, by signing a document, they are acknowledging that they have received notice. They're just not going to appear in the case. So if you're asking in terms of an eviction, in Texas anyway, that just doesn't exist. Notice is extremely important in eviction, particularly because it moves so fast. And so, and I know we don't all feel that way, but relative to other civil litigation, evictions run at lightning speed. So yes, I've heard of waiver in other civil matters, but it's not available, not in Texas anyway, for an eviction. All right, question number 3. Hey, I won an eviction. Great, good for you. Judgment included 1 month of rent. The tenant destroyed the apartment. Breaking the microwave, the stove, making holes in the wall, making holes in the pipes. They removed faucets, door handles. Do I need invoices to take them to court, or can I use pictures of all the damages and quotes to repair? Tenant signed the lease using an LLC that owns 3 properties in the county. Okay, so there's a lot in this one. There's a whole lot in this one. First, whenever I am counseling a landlord who's signing a lease with a registered entity tenant, let's say it's a commercial, and this is usually where it happens, but I see it also happen in residential, and I'm not super excited by this. But let's say you have an entity signing either a commercial or a residential lease. 100% of the time, you need a personal guarantor, somebody who's saying, look, anything that happens with regard to this case happens to me personally. Because a lot of times you're going to find that entities own nothing, that they go out of business, and once their bank account has been liquidated, there's nothing for you to go after. Now, in this case, it appears that this LLC may be the title holder of certain real property. That's good. And so what I would first recommend is going and doing what I talked about to establish a judgment lien earlier. Establish that judgment lien and seek to execute that first judgment first. In the meantime, go ahead and file that new lawsuit and proceed, if you have a new claim, to get a new judgment. And if you can prove all of your claims, you're likelier to win it. I'll tell you that the proof of what you actually paid is always stronger than proof of estimates. And sometimes landlords come to me and say, well, all I have are estimates. Well, have you done the repair? Yeah, but the estimates were too high, so I found Joe Bag of Donuts to do it, and he did it for a lot less. Well, then that's your actual damage calculation. If these facts come out in court, you can't claim somebody else's estimate, especially if your house was fixed at a lesser cost. That's your actual damage calculation. So stay away from estimates. Certainly you're going to want to take pictures of everything, but in order to recover properly, you're going to want to establish what either A, you will pay in the future, or B, what you have paid in the past. the amount you have paid is always the strongest evidence. Okay, next question. How long do you have to wait before you can go into your property after the tenants seem to have moved out? Well, you know, I always tell landlords, you probably, and we talked about inspection at the beginning, you probably have the right to enter right now, always. As long as you give, if your lease requires it, requisite notice, and you have a valid, basis, you got to show up in a reasonable manner at a reasonable time, and you got to do it peacefully. And as long as you're doing all the things you're required to do, you probably could go today. And so you don't have to wait. Your lease probably already outlines what your rights are to inspect the property. And so look to your lease. That's the best thing for you. I can't get into what every state will allow across the country, but certainly if your lease allows you the right to inspect, even without notice, I would still say shoot an email. Make sure you send out notice to that tenant that you plan to be there Saturday morning at 10 o'clock, and then show up. And if nobody's there and it turns out that the place is totally vacant, then immediately take possession. Now, totally vacant should mean totally vacant. That means 100% of their stuff is out. If it's mostly vacant, don't touch their stuff. Unless you're executing a writ of possession or some other writ from the court that allows you to remove all of their stuff, don't touch it if they're in the process of it. You're likelier to get some kind of claim, and you certainly don't want to lock them out. If they're moving out, just let them move out. But as far as going in there and inspecting, even taking pictures of the condition of your property, you can probably do that right now. Again, check your lease for what your notice requirements are and your local jurisdiction. If there are none in your lease, no requirements, you might want to seek out legal counsel as to what is allowed in your jurisdiction when your lease is silent on your ability to inspect. Number 5, is there a monetary limit when it comes to overdue rent? Is there a time limitation on when you can file for overdue rent? Scenario: tenant moves in, made no payment whatsoever, but promises to pay when his, quote, money comes in. It's been 2+ years and still not a dime paid. This sounds like a much bigger problem. Now they are offering to buy the property from the landlord. Yes, there is a lease signed. Well, my first question would be, why did you wait more than 7 days? I never recommend that a landlord wait more than 7 days before issuing a notice to vacate for non-payment of rent. But this doesn't sound like a situation where someone is going to pay the rent. Now, the idea that they might purchase the property, sure, they might, but this is a more complicated question than I can probably get into. How that lease is still in place after 2 years of non-payment, have the parties agreed on a sale price? What is that price? Is that price 2 years old? If it is, and it's part of the lease with an option to buy, does that number still make sense 2 years later? I never recommend that landlords, sign leases with options to buy and lock in a certain rate, because they have no idea whether or not the value of their property will just skyrocket. And now they're selling property to somebody at a dirt cheap discount when they could have sold it on the open market and made a killing. And so, no, I don't ever suggest that you sign a lease with an option to buy. Those tend to be messy. In this case, if he hasn't paid rent, get rid of him. But again, my deeper issue is, why is it taking you 2 years to act on this issue of non-payment? If what you mean is it's been 2 years of late payment, I guess that's another thing. But if he hasn't paid a dime, literally hasn't paid a dime in 2 years, that's somebody you just gotta evict. I doubt they're gonna come through and buy the house. Maybe they will, but again, complicated because of the things that we talked about. I don't know enough about the case to give really great advice here, but none of it sounds particularly good. Question number 6, Ernie, what if the tenant sends you partial payments for past due rent through Zelle, and you've already filed the eviction? Am I supposed to refund it? Will the judge throw out the case because they attempted to pay? I do want the tenant out since it's becoming a habit. They pay partial, late payments monthly. She doesn't respond to my calls, texts, or notices. Well, I like that you mentioned notices. And I hope that you have several notices that you can display to the court. And again, I hope they're in a format that you can prove you adequately delivered these notices to your tenant and that your tenant did not respond. All this is good evidence. Now, the fact that the tenant made payment after the eviction was filed could be taken into consideration. However, if there's still a balance left of unpaid rent, most courts will say, well, look, I'm not going to make you refund that, but you certainly have to credit it to the judgment balance. And so what I tend to tell landlords in these situations is the following. If I filed an eviction on day 1 and on day 10, a payment was made by the tenant, unsolicited by the landlord, but a payment was deposited by the tenant, and then on day 25, we're going to trial. So I always disclose that to the court. I say, look, Your Honor, we're seeking possession, we're seeking rent in the amount of X. However, I do want to disclose that a payment was received unsolicited on day 10. We have applied that to the amount owed. There's still a rent balance owed, and we would like to move forward with possession on that basis. However, if this court will not allow us to keep those funds and will instead prohibit us from possession, we are prepared to return those funds, but we await the order of the court. And so you put this matter in the judge's hands. Now, it could be that in your state, and some states will allow the tenant to pay the full amount of rent and fees owed up to the day of trial, and the case has to be dismissed. That's not the case in Texas. And so, for this specific set of facts, it's really dependent on your jurisdiction. But here in Texas, we often counsel clients and say, look, if you show up to the court and you really want possession, you probably can still get it, but be willing to refund that money. If it turns out that, and this is what 90% of courts will do, is say, look, let's just credit it to the amounts owed. I'll only give you a judgment for the remaining balance. But yes, you can have possession because you followed all the steps and their payment was made unsolicited after the eviction was filed and they continue to owe rent. So in that case, you probably can keep the money, but always, always, always be prepared to disclose that to the court at trial if a payment was received, again, even unsolicited, was received after the eviction was filed, and if the court requires it, be prepared to refund it to the tenant. All right, well, I've got these 6 questions. I'm going to take a quick peek at the screen. All right. Okay. I do not see any more questions, so we'll go ahead and wrap it up. I want to wish everybody a very Merry Christmas or whatever holiday you celebrate. Enjoy your holidays over the next few days. We will not be back until the month of January. So we're closing out the year. I hope that each of you start off 2025 in good spirits and with a few tips from us to improve your landlording skills. I want to thank you all who watch and who have contributed questions and who continue to enjoy this channel. And until next time, landlords, happy leasing.